federal jurisdiction. And, we've talked about this before. We've had the lovely Lisa Jemison talk about this many times, as she and their firm, Jemison Fisher, have been very heavily involved in working with NCAT to get processes around federal jurisdiction. We've probably been talking about it for, over 3 years now. So this is where, how does it, what is it affecting? Now, it affects a number of cases, but let's just talk about the property ones, hey? Because that's what we're here to discuss. So if at the time of lodging an application at NCAT, at the New South Wales Civil and Administrative Tribunal, one party is a permanent resident of one state and the opposing party a resident of a different state, NCAT will not be able to determine the matter. Okay, now let's have a look at when that doesn't apply. It doesn't apply if one of the parties is a corporation, so a proprietary limited company. It doesn't come into play if one of the parties is a resident of a territory, that's Northern Territory or Australian Capital Territory. It doesn't come into play if one of the parties is a non-permanent resident of a different state or the party resides overseas. So obviously this is mostly in property issues. This is mostly the case, or commonly the case, arises in residential proceedings when the landlord resides interstate. It can be the flip side though, when the tenant has moved and then makes a claim after they've moved and they've moved interstate, so their new address is in a different state. So that's when these issues have to be looked at. So what happens if there is a federal jurisdiction problem? Now you can still apply to NCAT, and NCAT will assist you come to an agreed settlement with the other party. So if you're representing the landlord, then they will help you on behalf of the landlord come to an agreed settlement. So, however, if you don't settle the matter, and you want to have the agreed settlement, or you want to have an agreed settlement registered and enforced, you will actually need to take that to the local or the district court, depending on the size of the claim, obviously. Now, the court is able to make the same orders that NCAT could have made, but it's a different process. So, now if you go to NCAT and they say, no, we can't hear the matter, you'll need to take certain documentation with you. You obviously need to take the letter that NCAT will give you that states that NCAT declined to hear the matter based on the federal jurisdiction matter or issue. You need to take with you a copy of the application or appeal that you lodged at NCAT, so all of the pre-documentation that you've already done. And obviously, if a settlement had been reached, a copy of that agreed settlement. You will also need to complete, here's the sting in the tail on this one, you will also need to complete the relevant court summons and affidavit. And now here is where, as a property manager, the older property managers who used to do this and go to courts, 30 plus years ago, they go, yeah, done that. This is the old days. They know very well how to go to court and run a residential tenancy matter. However, most agents do not. And this is where we need the help of solicitors. So in terms of preparing those documentations, particularly the affidavits, making sure that they are prepared appropriately for a court. Now, you can attempt to do it. All of that information is on the NCAT website and, go for your life. But it's certainly, I would be saying your first port of call would be, let's check the landlord's landlord insurance to see whether they are covered for federal jurisdiction matters. Some are, some are not. So that's a question that needs to be asked. We often get the question, I know that the landlord lives interstate, therefore, can I just go, do we just go to court directly? Now, if an Act of Parliament actually states that a matter can only be heard at NCAT, such as a residential, under Section 119 of the Residential Tenancies Act, or an anti-discrimination matter, no, you can't, because it has to go to NCAT first. They have to rule that they cannot hear that matter, and they can't determine the matter. So that needs to go there first. So and that'll be the case for all of your residential tenancy matters that you're dealing with as an agent. So, guys, it's a fairly, I guess, involved issue. But if you have, and it's usually the case where the landlord is living interstate, then you have an issue to deal with. So check the landlord insurance, check where you're going to get additional assistance from, and talk to your landlord about it. This is a discussion that needs to be had, because there are significant dollars once you start getting a solicitor involved, and even if it's being a certain amount is going to be covered by landlord insurance, the landlord needs to understand that there are additional expenses involved. It's not going to be like you running down to NCAT or hopping on the phone and doing an NCAT hearing at a much lesser cost. So, guys, that's a bit of an update on the federal jurisdiction issue.